Horibata, Terry L. Ridon, and Hernandez. House Bill number 6766, an act disqualifying relatives of public officials within the fourth civil degree of consanguinity or affinity in all government contracts by Representative Audrey Kay Zubiri. House Bill number 8144, an act disqualifying relatives of public officials within the fourth civil degree of consanguinity and affinity in all government contracts by Representative Bernadette Escudero. House Bill number 8430, an act disqualifying relatives of public officials within the fourth civil degree of consanguinity and affinity in all government contracts by Representative Charisse Anne Hernandez. And House Bill 8650, an act disqualifying relatives of public officials within the fourth civil degree of consanguinity and affinity from all government contracts and providing penalties therefore by Representative Eric Goyap.
Mr. Chair.
Yes, Representative Bangcoro.
Thank you, Mr. Chairman. Mr. Chairman, on House Bill numbers 4701, 4770, 5789, 5940, 5981, 6766, 8144, 8430, I move that the explanatory notes of these House bills, Mr. Chair, will be considered as the sponsorship speech of the respective authors. I move accordingly, Mr. Chair.
Thank you very much, Representative Bangcoro. Maybe direct the committee secretary to note the manifestation made by Representative Bangcoro that the explanatory notes of the mentioned bills will be entered as their sponsorship speeches. Now that we've heard all the bills that are pending before this committee, may we now hear from our resource persons. Yes, Representative Jokno.
Thank you, Mr. Chair. If I may be allowed to make a brief manifestation. Thank you. Magandang hapon po, esteemed colleagues at resource persons. Unang-una, buong paggalang kong ipinapahayag ang aking suporta sa mga House Bill na naglalayong ipagbawal ang pagpasok sa government contracts ng mga kamag-anak ng mga public officials hanggang fourth degree of consanguinity or affinity. Napakahalagang hakbang ito, Mr. Chair. Itong mga panukalang ito ay kailangan natin para mapalakas ang transparency, accountability at integridad sa ating public service. Sa pamamagitan ng pagtatag ng mas malinaw at mas mahigpit na panuntunan laban sa conflict of interest, masisiguro natin na ang paggawa ng mga kontrata ng pamahalaan ay nakabatay sa patas na proseso at tunay na kapakanan ng mamamayan. Naniniwala po tayo na mahalagang mapanatili ang tiwala ng publiko sa ating mga institusyon at lalong-lalo pa ay maprotektahan ang pondo ng bayan laban sa anumang uri ng undue influence, pang-aabuso o korupsyon. Kaugnay nito, magalang ko rin ipinapahayag ang aking hangarin na maisama bilang co-author ng consolidated versions ng panukalang batas. Isa lang pong nakita ko na that I would also like to share with the committee would be I hope that we can avoid using the data privacy law to prevent our public from gaining access. I understand many of the bills have call for the creation of a registry where the public can access data. I'm just concerned because in some other situations, kuminsan, although legitimate naman ang data privacy law, ay imbis na nakakatulong siya, nakagiging shield pa siya from access of the public. Ayun lang po. Maraming salamat.
Thank you very much, Representative Jokno. The committee welcomes your manifestation and we note your comment regarding the data privacy law concerns being used as a shield to the passage of this law. Committee Secretary, please note the manifestation and the comments made by Representative Jokno. Let's now proceed with the our resource persons. The Let's do it law school style. Who wants to volunteer? If not, I will start calling names. Yes, ma'am. From our Securities and Exchange Commission, Attorney Castillo.
Yes, good morning, Mr. Chair, and good morning to the Honorable Committee. At the outset, the Commission wishes to express its gratitude to the Committee for giving us the opportunity to manifest our comments on the proposed legislative measures. So we fully support the objectives of the bill, particularly its intent to consider beneficial ownership, and we shall endeavor to submit our position paper on the matter at the earliest possible time. Of particular interest to the Commission are the bill's definition of beneficial ownership. In this regard, we note that the Commission has released guidelines on beneficial ownership, which provides an extensive definition on the classifications of beneficial owners. So, to provide us a quick overview of what these beneficial owners are, I cede the floor to Attorney Ian from the Commission's Anti-Money Laundering Division to provide the esteemed committee with a brief background on the concept of beneficial ownership.
Thank you, Attorney Castillo. Attorney
Your Honor.
Ian.
Yes. Good morning, Mr. Chair and members of the committee. So, under the Securities and Exchange Commission's Memorandum Circular Number 15, Series of 2025, promulgated last December 2025, the Commission has defined beneficial owner as any natural person who ultimately owns or controls or exercises ultimate effective control over a corporation or a legal entity. Under the same circular, it further categorizes what a beneficial owner is. So basically, under the circular, we have categories A to I, which in sum defines or categorizes beneficial owners based on ownership, which is 20% of the voting rights, voting shares, or capital of the reporting entity. It as to other certain categories, it further categorizes it to based on contractual control, board election power, dominant influence, direction of board, property stewardship, nominee arrangements, and other control mechanisms. And lastly, if there are no natural persons that people could identify per corporation, it's the senior management. So under the said circular, as you could have noticed, the definition and categorization of a beneficial owner does not solely pertain to shares inside a corporation directly or indirectly, but it strictly includes the ultimate control as well, other than the ownership parts. That's all.
Thank you, Attorney Ian. Any questions from our members of the committee? But thank you for that. Your clarification on beneficial ownership. Because as far as the layman would consider shareholdings as the test of beneficial ownership, but I think your explanation will give it a more concise and more or a clear view. May we request the SEC to provide the committee with the exact the categories that you mentioned aside from the shareholdings?
Yes, Mr. Chair, we will be including that in our position paper.
Thank you very much. Just one question. You mentioned categories A to I. Do we have to, in considering beneficial ownership, we consider all categories, or we just, if one is ticked off, it's already considered a beneficial owner?
Under SEC policy, Mr. Chair, we consider every category. So from A to I, as all those categories, actually categories A to H could simultaneously be considered as a person could be simultaneously considered as falling under categories A to H. It is only the category I which being exclusive, as it is an umbrella if there are no natural person that could be identified. So we likewise consider the senior management as a beneficial owner of the corporation, Your Honor, Mr. Chair.
Yeah, thank you. So to be considered a beneficial owner, you have to be ticked off in the A to H category.
To supplement, Mr. Chair, any if the beneficial owner falls under any of the categories, they are already considered a BO. But yes.
Balik, kahit isa doon,
Kahit-
beneficial owner ka na. It's not all. Okay.
Yes, Mr. Chair.
All right. Anyway, we'll wait for your position paper. Thank you very much, Securities and Exchange Commission. Who wants to be next? Yes, ma'am. Ma'am, please introduce yourself na lang.
Yes, good morning. I'm Attorney Alviola from the Governance Commission for GOCCs.
Yes, ma'am. Please proceed. Thank you.
Yes, sir. Honorable Chairperson Tanuatco III, distinguished members of the Committee on Revision of Laws, and esteemed colleagues in government, a pleasant day to all. The Governance Commission for GOCCs expresses its profound gratitude for the invitation to participate in this initial deliberation regarding House Bill numbers 3661, 4701, 4770, 5789, 5940, 5981, 6766, 8144, 8430, and 8650. At the outset, the Governance Commission unequivocally supports the enactment of these legislative measures as the disqualification of relatives of public officials within the fourth civil degree of consanguinity or affinity from participation in government contracts constitutes a reasonable and necessary protection. This reform directly advances the constitutional principles of accountability and transparency in public office by reinforcing the foundational principle that public office is a public trust. The proposed measures are fully consonant with existing governance standards established by the GCG, such as GCG Memorandum Circular Number 2012-07 and 2012-05, which already mandate the GOCC directors and officers avoid conflicts of interest and act solely in the best interest of the state. We note, however, that while internal mechanisms regulate the conduct of public officials, they may not sufficiently address the broader network of relationships through which influence can be exerted. By extending the disqualification to the fourth civil degree, these bills operate as a necessary complement to existing rules, ensuring that conflict of interest safeguards remain effective rather than illusory. To ensure the successful implementation of these measures within the GOCC sector, the Commission recommends precisely calibrating the prohibitions concerning juridical persons. We posit that the disqualification should attach to an entity only when the relative in question occupies a position of significant influence, such as a beneficial owner, as we have been discussing earlier, Mr. Chair. Also, corporate officer or a director with the power to control the entity's participation in a contract. This granular approach maintains the integrity of the bidding process while respecting the distinct personality of the corporation and protecting passive minority shareholders or ordinary employees. Furthermore, we find great merit in the post-tenure disqualification period and the establishment of a centralized conflict of interest registry. Integrating such a registry with the GCG's integrated corporate reporting system, because we have that in place, Mr. Chair, it would facilitate seamless cross-referencing and empower oversight agencies with real-time data for verification. Regarding the penal and procedural aspects, the Governance Commission humbly suggests the adoption of a graduated penal scale to ensure that penalties remain proportionate to the gravity of the offense, harmonizing these measures with existing statutes like Republic Act Number 3019 or the Anti-Graft and Corrupt Practices Act. Uh, we also recommend that the GPPB be designated as the lead agency for the promulgation of the implementing rules and regulations, with the GCG, of course, performing a collaborative role to ensure the unique governance considerations of the GOCC sector. Mr. Chair, we would like to inform the committee that the observations and recommendations provided herein are based on our initial technical review. We manifest that the Governance Commission will submit a signed and finalized copy of our position paper as soon as it has been formally approved by our principals. Thank you, and we look forward to contributing further to the refinement of these significant legislative reforms.
Thank you very much, GCG. Regarding the position paper that you mentioned, can the committee request that the what you mentioned earlier, the position of significance when it comes to the application of the prohibition, if it could be clearly defined? Yeah, if we say that the position has to have some sort of control or maybe influence, is it feasible to put a to define or to be specific as to which positions, or to keep it general? Again, we'll wait for the position paper. Maybe you could put some focus on that aspect, so we know which positions are considered of significance.
Thank you, Mr. Chair, for that. As an initial overview, we have defined it by the percentage of shareholdings, but we will provide the necessary position paper signed by our principals, Mr. Chair.
All right, thank you, GCG. Any volunteers? Next, GPPB. Attorney Lopez.
Good morning, Honorable Chairperson, Honorable Committee, and esteemed colleagues in government resource persons. The GPPB also expresses its gratitude for the opportunity to contribute to this deliberation and to discuss our inputs today on the proposed measures. So at the outset, the GPPB also expresses its support for the general objectives of the bill. We support any measures that seek to enhance transparency, integrity, and accountability in government procurement. And of course, everyone understands that corruption is a plague upon government procurement. As was recalled earlier, the current safeguards that we have in place relative to procurement are limited to the third degree of consanguinity or affinity, and this is restricted to officials within the procuring entities. We note that this safeguard, as reflected in an omnibus sworn statement required to be submitted, was carried over by the wisdom of this committee when RA 12009, the new Government Procurement Act, was enacted. So we wish to highlight from a procurement standpoint the potential consequence of the proposed prohibition as it stands. One of the governing principles of procurement would be competition, ensuring a playing field that involves all eligible and qualified bidders. And we note that the prohibition in its current form may have the effect or the consequence of restricting the available pool of bidders, of disqualifying potential participants in procurement projects who may have had no relation or no ability to influence the project at hand. So we note that one of the objectives for government as well in procurement is to ensure the best value, or to ensure contracts that are most advantageous to the government. So we wish to highlight that this is one of the concerns that the GPPB wishes to raise with regard to the proposals. We also clarify that the mandate of the GPPB is limited to rendering opinions on matters involving the interpretation of procurement laws, rules, regulations. So while we are happy to provide our assistance to other aspects, we also clarify that it is it may not be within the mandate of the GPPB to be in charge of the proposed repository or central database of conflicts of interest, as well as to make determinations or to certify as to the nature of procurement projects. So, incapacitating our procuring entities, we also want to give them the ability to discern the needs of their procurement projects, their requirements, which leaves them in the best position to determine if their projects are highly technical or scientific. So, with this balance of empowering our procuring entities, but also trying to give the appropriate guidance, we note that certain matters may be revisited as regards the specific role of the GPPB, but we nonetheless affirm our commitment to supporting and providing our policy advice where able, and we can provide a position paper as well to summarize our observations that may have an impact on procurement, particularly the breadth of available bidders and suppliers that may participate, and the impact that this may have on the efficiency of the procurement process and the ability of qualified and eligible suppliers to compete with the where they are available. So thank you for the opportunity, Mr. Chair, and we can prepare our we can finalize our position paper and submit the same in due course.
Thank you very much, GPPB. Just one clarification with what you mentioned. The agency is concerned that if the bill is passed and becomes a law, there there is a concern regarding the possible disqualification of some bidders because of relationship issues.
Yes, so we might effectively be restricting the available pool of bidders who would be qualified to participate in the first place, since they may potentially be related to numerous procuring entities, even if, for example, they are related to. They may have relations with officials who are not involved in the specific procurement project for which they are participating. So we understand that what we are trying to address is a conflict of interest, but we also seek to balance that with the ability to also actually participate and provide services. So we just note that there may be cases where the conflict of interest may not arise necessarily, since the relationship does not exist with the with this procuring entity, but rather with another subject which for which they are not bidding.
May I interject?
Representative Bangkoro.
Thank you, Mr. Chairman. Can you give us inputs or insights? Because in the definition of term here of public official, there is no distinction between the elected and the appointed. Now, in the case of senator or cabinet official, secretary, they're holding a national government positions. If they're members of the family within the fourth civil degree will join a bidding in a local government unit, of course that is not under in their jurisdiction. They are be considered barred or prohibited insofar as this legislation measure is concerned?
Yes, that is the kind of situation that we are foreseeing may occur.
Any other comment from other resource persons? Because it would be very difficult to us to define if a certain government official, whether elected or appointed, if we parang lahatin na lang natin na bawal. Kasi kunwari, si cabinet official is, or sabihin natin, hanggang saan rin yung covered from secretary lang ba? Hindi na sasama si undersecretary or si assistant secretary? So, paano natin ma-define na makukover siya even though that particular procuring entity is not belong to his agency? Sabihin na natin, kunwari, si DNR, secretary, may kamag-anak siyang sumali doon sa DPWH or si DPWH undersecretary, may kamag-anak siya within the 4th civil degree, sumali doon sa isang LGU. So, how could we put in place? Can you give us some insights? Or perhaps you can submit some position paper for that matter so that this committee can study of this. Anyway, in our, there are sections in the proposed measure that we can come up internal, IRR, no? Implementing rules and regulation. But it would be best for us, before we pass the law, there is a clear-cut definitions, because if this particular situation is gray, then it could be subject for court litigation. So mahirap na yung kailangan pa mag-interpret yung mga judges or justices for that matter. Thank you, Mr. Chairman.
Thank you, Representative Bangcoro. Would the GPPB like to reply to that, or any other resource person who want to? Yes, sir, GPPB. Mr. Bareng.
Good morning, Mr. Chair. I totally agree with Honorable. Sorry, basa. Sir, currently, the rule is to bar the bidders that has a relationship up to third degree civil consanguinity and affinity within the procuring entity concerned. So for example, kung sasali po siya sa isang procuring entity at meron siyang kamag-anak doon, to avoid conflict of interest, favoritism, and direct access to information regards to the procurement, pinagbabawalan po yun. So currently, as the proposed measures are worded, it appears po kasi na blanket prohibition siya. So regardless kung meron kinalaman sa procurement at hand nung public official at kamag-anak ng bidder na sasali, madi-disqualify po siya at the outset. So yun po nung tinitignan ng GPPB as one of the consequences of that blanket prohibition po. So ang possible recommendation namin is to limit that prohibition to the procuring entity concerned lamang. So kung sakali mang may kamag-anak siya from other offices pero hindi malayo dun sa kanyang sinasalihang procurement or procuring entity, dun po siya maaari pang pagbawalan po. So yun lang po, Mr. Chair. Thank you po.
Thank you, Mr. Bareng. I think your explanation clarified a lot of concerns by Representative Bangcoro. Would other agencies want to comment on that or add to the, or are all in agreement with what the position of GPPB is, or just said that to limit the prohibition within the procuring entity? But I guess there are no violent objections to that interpretation. So thank you, GPPB. Next agency who wants to? DepDev?
Good morning, ladies and gentlemen. Good morning, Mr. Chair. So we're from the Department of Economy, Planning and Development. I'm Joy Divinagracia from the Governance staff, and I'm with Mr. Ernest Diaz from the Infrastructure staff. So we've reviewed similar bills, and our our position is that we support any bill that aims to strengthen safeguards against potential conflicts of interest and promote integrity in government contracting. The bills are timely, as recent corruption controversies have created a need to rebuild trust in government through a clear and credible institutional response that enforces transparency and accountability. So we submit some of our comments. So for instance, the breadth or the extent of the prohibition in the bills extending to the relatives of government employees with supervisory and managerial functions could reduce competition in procurement, given the number of personnel across all levels of government. Also, we observe that existing procurement laws and policies already provide adequate safeguards against conflict of interest. For instance, we have the disclosure of relationships between bidders and key procurement officials. We have the disclosure of beneficial ownership and disqualification of bidders or inhibition of procurement decision makers in cases of conflict of interest. So with this, the occurrence of irregularities, despite these safeguards, suggests the issue relates less to the absence of rules and more to the institutional capacity to verify and operationalize disclosures, including the ability to strictly enforce such rules and impose penalties for violations. So with this, we submit that strengthening institutional verification capacity and contractor information systems may be as important as and more effective than expanding disqualification rules. So expanding government data on procurement and registered entities and improving the accessibility thereof would help address corruption issues by enabling the identification of irregular patterns, improving the traceability of transactions, and increasing the likelihood of detection of irregularities. So we may focus on strengthening contractor information systems, improving procurement data integration and transparency, and strengthening institutional capacity for procurement oversight. So all in all, DepDev supports policy measures that strengthen transparency, integrity, and accountability in government contracting, which can be best pursued by strengthening institutional systems for verification, monitoring, and oversight. Thank you.
Thank you, Ms. Joy Divina Gracia from the DepDev. Again, similarly, we would welcome your position paper to be submitted to the committee. May we hear from our ULAP, Mr. Edmond Quaresma.
Good afternoon, Chairperson Tan Huatco and honorable members of this committee. I'm Edmond Deo Quaresma, representing the Union of Local Authorities of the Philippines, and we thank you for inviting us to this session and reaching out to us for comments on the proposed bills seeking to disqualify relatives of public officials within the fourth civil degree from participating in government contracts. While we are still discussing the proponents of our position paper with the National Executive Board of ULAP, we express our support for the intent of the proposed measures which seek to strengthen transparency, accountability, and integrity in government procurement and contracting. The proposed measure advances a preventive, systems-based approach through the institutionalization of disclosure requirements, recusal mechanisms, and a centralized conflict of interest registry aimed at addressing actual, potential, and perceived conflicts of interest in public transactions. ULAP recognizes the importance of restoring public trust and ensuring fairness in government contracting. However, we underscore the need to calibrate certain provisions to ensure operational feasibility for LGUs, preserve competition in local procurement markets, and protect legitimate local economic participation. ULAP therefore advocates for a proportionate and context-sensitive framework that balances integrity, safeguards, with practical implementation at the local level, while ensuring adequate technical and institutional support from national government agencies. We will submit our official position paper once it is approved by the National Executive Board. Thank you.
Thank you, Mr. Quaresma from the ULAP. Again, position paper. And now from the PCC, Attorney Guadalupe.
Yes, good morning,
Good
Mr.
morning.
Chair.
Ma'am?
Good morning, Mr. Chair, to the honorable members of the committee and distinguished colleagues in the government. So, the PCC would like to express its gratitude in being invited to the deliberations of the proposed measures. We recognize the policy objective of these measures in ensuring that government procurement remains open, fair, and competitive without undue influence or advantage. We support the policy objective to strengthen safeguards against potential preferential treatment and manipulation in government contracting, though we do take note the issues raised by our colleagues from the GPPB and DepTev with regard to the possible limiting of suppliers, the pool of suppliers, if the blanket provision is retained perhaps in the proposed measures. So perhaps the PCC could just submit its position paper with regard to this and whatever other concerns we may have.
Thank you, Attorney Guadalupe. Offhand lang, no? Is that a concern also of the PCC? The concern of GPPB and the GCG, I mean DepDev, regarding if the scope of the prohibition is blanket, then there is really the possibility of limiting the number of contractors or number of bidders, suppliers.
I think this is more of a concern for the GPPB, but we also do recognize that if you do limit the pool of suppliers for your procurement concerns, that would limit the government's market and you would have less competition in your procurement. So we recognize the issue that was raised and we will provide our opinion and whatever support that we can provide to the committee with our position paper.
Thank you, Attorney Guadalupe. Let's go back to GPPB. Yung concern about the limiting of the suppliers in case there's a broad prohibition, is that a function of foresight or is it because of experience right now?
Both, Mr. Chair. So, as a function of foresight, it would be quite difficult also for the procuring entities to be able to conduct, for example, even at the level of market scoping, they would already have to determine if their prospective bidders are disqualified. So even at earlier stages of procurement, this may be a limitation or a restriction for them. And as a function of our experience as well, there are many instances of procuring entities that have to keep going through the process because of limitations in the availability of bidders for certain kinds of projects. So we would say both.
Thank you, GPPB. Maybe here from the Sandigan Bayan, Attorney Jason Lorenzo.
Good morning,
Since
Mr.
you will
Chair.
be hearing some of the cases, if ever.
Good morning, Mr. Chair. Good morning to the honorable members of this committee and to our colleagues in the government service. Mr. Chair, the Sandigan Bayan is one with this committee in ensuring integrity in our government procurement processes. The Sandigan Bayan is also one with the committee in ensuring transparency in government contracts. With that being said, Your Honors, may we just request that the Sandigan Bayan be given the opportunity to submit its formal position paper regarding the contents of the House bills now under consideration. We just have to discuss it with our NBank. Whatever position that the Sandigan Bayan will be taking regarding these proposed laws will have to be cleared first with our NBank, Your Honors. So with that, Your Honor, may we just respectfully request that we be given time to submit our position regarding these bills. Thank you, Your Honor.
Thank you very much, Attorney Lorenzo. Yes, Representative Jokno.
Thank you, Mr. Chair. Just a question to all of those who have stated that baka mahirapan ng mga bidders at wala na mag-qualify. So this is GPPB and some of the others have spoken. Would that not be possibly a temporary problem? Because as I understand the situation now, there are really a small pool of companies that contract with the government. But one of the reasons for that might also be because of the perception that kailangan meron silang connect o may influence sila sa loob para makuha nila yung bid. But once, for example, we get to have more transparency, for example, with these bills, if they become laws, then while temporarily it may be a difficulty, I think that would now encourage more companies to bid, knowing that mas transparent na ngayon. Hindi na kung sino ang kilala mo sa loob ang makakakuha ng ma-award, kung hindi kung sino talaga yung dapat mabigyan. That's one question I have, Mr. Chair. I might as well take this opportunity. Could we also invite at the next hearing a representative from the Data Privacy Commission so we could hear from them? Yan po ang tanong ko sa inyo. Thank you.
GPPB, would you have to reply to the...
Yes, sir, that is actually a good perspective to look at the impact of the proposed measures as well. We would welcome an environment that feels more conducive for all bidders to participate. So I think what we can achieve or what we can consider to balance a desire to create a more open environment or an environment that feels more competitive, more it feels like a more even playing field for all bidders, while also recognizing the realities of procurement processes and requirements. As mentioned by my colleague, perhaps we can look into perhaps modifying the prohibition, some additional qualifications that at least clarify in what situations the prohibition would apply. I think if we are able to demonstrate that we are pushing for a more transparent and inclusive process, but without perhaps hampering or making it more difficult for the procurement process or compliance with that itself, then I think both of these interests can be pursued. So, but we will take this perspective into account as well.
Thank you, GPPB. Any other agency who want to reply or comment on the statements made by Representative Jokno? I think it was Dev and GPPB that were concerned about the Dev. Do you want to? No.
Mr. Chair, DepDev will look into the concern raised by Representative Jokno and will be including it as well in our position paper. Thank you.
Okay, thank you. The committee secretariat is, please note that we invite a representative from the data privacy during our next hearing. Last but not the least of our resource persons, Department of Justice, Attorney Carla Kalugay.
Good morning, Mr.
Hi, good morning, Attorney.
Good morning, Mr. Chair, and to the honorable members of the committee, as well as to the distinguished colleagues from the government. The Department of Justice interposes no legal or constitutional objection to the proposed measure, and we express our support on the objectives of the proposed measure as it aligns with the state policy to maintain honesty and integrity in the public service, as well as take positive and effective measures against graft and corruption. We also recognize that the proposed measure will further strengthen our legal framework as it seeks to extend the prohibition currently provided under the Procurement Act to the fourth civil degree. Moreover, the proposed bills also conforms with the Philippines' obligations to uphold international best practices, including those embodied in the United Nations Convention Against Corruption, as it as one of the Philippines' obligation under that convention is to consider establishing effective financial disclosure systems for public officials. So, in line with this, Mr. Chair, the department will endeavor to submit our official position paper once it has been cleared by our principals, and we await for the consolidated version of the proposed bills. Thank you, Mr. Chair.
Thank you, State Council Kalugay. I don't want to be the person to add more work to your already busy workload. But considering that this is a LEDAC measure, there is a sense of urgency that we draft the substitute bill sooner than later. So may we request all the agencies present today to submit your position papers by Friday, the latest, so that by next week, well, over the weekend, the committee can start working on the substitute bill and start reconciling the divergent provisions. Again, we, together with you, would want to get this bill passed into law soonest. So we would appreciate your compliance with the period by Friday to submit your position papers. Any other agency would want to give their comments or suggestions or further remarks? Okay, at this juncture, the committee would like to thank everyone present today for your attendance and for your comments, your very valuable comments that will help the committee in drafting. May we hear a motion?
With that, Mr. Chair, I move that the deliberation on these measures will be suspended until May 18.
There is a motion to suspend the proceedings until May 18, duly seconded by Representative Jokno. Any objections? Hearing none, said motion is carried. There being no other matters to be discussed, may I hear the favorite motion of everybody?
Move the adjourn, Mr.
A motion to adjourn? Thank you. Thank you. Maraming salamat sa pagdalo ninyo. We'll be looking forward to your position papers by Friday. Oh, yes. There is lunch will be prepared. So you can stay, kung di kayo nagmamadali, kung wala naman kayong urgent, the committee will provide and serve lunch. Thank you again. Thank you.